And we are live. I am attorney Justin Sterling. This is Coffee with a Lawyer. Every Monday, 9 a.m. Pacific Standard Time. We like to take your questions for free, general legal information. Please know that there is no attorney-client privilege here. There is no confidentiality because we are streaming. There are third parties watching. We do have a special guest here that I'd like to allow for her the opportunity to ask a question. If anyone's viewing online, please feel free to type in the chat any questions they may have. So without further ado, so how may we help you today?
Okay, so I have a situation with a company that has charged back 4 times. I did 3 services, but they charged 2 of the one service back twice. Okay, and she said the reason was because they didn't know the name that the chargeback was, but I had already disclosed that on the invoice. So I'm trying to see how can I handle this because I believe this company has robbed me.
Understood. I would say hindsight is always 100%. In these type of transactions, it is best to use credit card for the form of payment because the credit card company serves as a third party intermediary, and there is a period between the until when those transactions actually go through. So there is a time delay for when you can contest these with your credit card company. And I know hindsight's 100%, but this is why it is good practice to make transactions on your credit card company. Now, in terms of the fraud, I think your best chance to nip it while you can is with your bank. Okay, so I would start contacting your bank manager to try to reverse the transaction if possible. It may not be possible. These type of scenarios are difficult because the money has transferred, the money has changed hands, and it's difficult to get it back once it leaves. Do you understand?
So let me explain to you.
Mm-hmm.
Okay.
Well, without getting into too many specifics, because we are streaming live, and again, there is no confidentiality. Let's just speak generally. If you can speak hypothetical,
Okay.
that's better.
So this was a situation. I'm the person that they did the service with. So they gave me their credit card information to charge them for the service. They claim they didn't recognize the name on there. So they disputed it for all 3 services, but 2 of the services was the same. So it's a total of 4 chargebacks.
Okay, let's take it a little bit slow. And I think you've done a very good job. This is a matter of first impression for me, so it does take me a little bit of time to evaluate the facts. I think I understand. First exercise I would tell any client is to make a chronology of events, timeline, because this is an exercise in getting the story straight. And then also these facts, this chronology, will be used as your allegations, your factual allegations in any complaint. So it's important to take the time and make sure it's very detailed and have an attorney review it and go through it, because there may be a more appropriate way to state a certain fact. Not everything's so black and white. It is quite gray, and choice of words do matter. So it's important to have it reviewed by an attorney, and then this will become your allegations in any complaint. Now, I understand the situation. As far as I understand it, it seems like they canceled the charge before it actually went through for the services that you provided. Is that correct?
No. Okay. So each and every time I submitted them invoice for each service.
Mm-hmm.
So this is 4 times, but twice on one, but 4 times. Okay. So they knew we had a history of doing business.
True, that's
Okay.
important. That is important.
Yeah. And then what they did, probably about 3 weeks ago, they charged all of them back.
Understood. It would be considered, and okay, few foundational questions. And because we are streaming, I don't want to get into too specifics, but one of the foundational questions is, what is the amount in controversy? What is the amount we're talking about? Because that will determine what jurisdiction you're in, what venue you want to file a complaint in, whether it's limited jurisdiction, unlimited jurisdiction, or even small claims. And in California, small claims, you're not allowed to have an attorney. You go in there representing yourself without an attorney. Other states are different. I don't know what other states are, but I do know California in small claims, you're not allowed to have an attorney. But then there's other types of jurisdictions that you can file your complaint in terms of the jurisdictional amount, the amount in controversy, limited and unlimited. The amount is $25,000. Complaints in which you're alleging more than $25,000 are filed in unlimited jurisdiction. And for your case, I believe your cause of action would be breach of contract. You fulfilled your end of the deal. You fulfilled all conditions. You took care of your obligations. Now their duty to pay is ripe. They have to fulfill their side of the deal. They are in material breach. They received a benefit, but they did not satisfy their conditions. Okay? So your appropriate claim would be against the other party that you contracted with for breach of contract, and possibly even fraud type allegations as well. But I believe the strongest cause of action is breach of contract. There are some cases you may want to assert more than one cause of action and throw the kitchen sink at them. Maybe allege, who knows, as many as are applicable. Then there's other situations you want to keep it quite simple and clean and just allege one nice, clean, simple cause of action, breach of contract. In your case, I do think you should allege other ancillary claims: fraud, misrepresentation, promissory estoppel, if for some reason they may not find an enforceable contract, because I don't know how you contracted with this party, if it was signed, if it was only done by emails or even just a handshake. I don't know. I don't know how the deal was made. But what is the control?
So it was contract, and they signed it.
Good,
yes,
because
and they agreed to pay. Yes.
Good, because the controlling terms.
Signed a contract. Yes.
Good. The controlling terms will be that contract. And I'm sure it is basic and it says they owe you a certain amount for your services. And the fact that you have, like you said, a history of doing business together, you have a past course of conduct, you have a history. The fact that they drew back the charges could be evidence of some type of intentional malicious conduct to defraud. I don't know. All right. You do have to get into the behaviors of the parties.
Okay.
Past history is admissible evidence to show how the parties behaved, that they had a prior business relationship, that they should be held to a better understanding of each other, a higher standard, because they've done business together. They know how the other operates. They know what is an acceptance. They know what is an offer, and they know what are the expected terms, the expectation under the agreement, because of the past history of working together. So there is a more clear expectation. I think it's more of an egregious breach in your situation. Now, it does come back to the amount in controversy. What is the amount we're talking about? And you don't have to disclose that, but that's something to consider. Where are you going to file? How are you going to handle it? It is a cost-benefit analysis. Is this a case where the value is worth pursuing? Some people will breach contracts with the anticipation that the other party won't pursue the claims because the amount in controversy is de minimis as compared to other deals. Do you understand? Some people just may not, they have a lot of these breached agreements and they're just sitting on these somewhat, from my perspective, assets on how they can collect the damages from them, but they just do an evaluation that they may not be worth it. And that may be your situation. Some people breach contracts thinking that they won't be pursued. They do an efficient breach analysis where they may think it may be better for them to breach this contract, take this other deal, and incur the risk of possible exposure if you so choose to pursue them. Does that make sense to you? There is a concept of what we call efficient breach. It's neither right nor wrong. It's more of a business decision. It's more of an objective economic perspective of contracts. But that doesn't mean that it doesn't mean that you're not still entitled to your damages for this breach. It's still a breach. I would, in your situation, you do have to evaluate what's the amount in controversy. Is it worth it for you to go pursue any claims against them, and how do you pursue these claims against them? Maybe you want to try to pursue this in pre-lit with a few demand letters and see where you get with that. In some situations, you could even assign your rights to this contract to a collections company to pursue them. I don't know what type of business you're in or if that's something you may want to consider, but if you are in business and you are facing these type of situations where clients are breaching your contracts and you have many of them, you may want to consider reaching out to a collections company to assign your rights under the contract to them, and they may buy it for you for pennies on the amount, but it's still a consideration if you have a lot of these outstanding balances, breaches of contract. Does that make sense, ma'am?
Yeah, that makes sense. But I think I would want to try to go for the damages because about the way that the conversations were going back and forth in the emails. So, yes.
I understand. Well, I must also forewarn you about cases that you take emotionally charged. And I understand maybe some email communications may have gone back and forth and they may have been emotionally triggering, but you do have to consider a case objectively, and it is a cost-benefit analysis. In these type of cases, they may not be what some people understand to be contingency fee arrangements with the lawyer. These are not cases in which the lawyer may share in a recovery. Generally, it depends on the amount in controversy and how persuasive your facts are. Each case is dependent on its own facts, but you do have to do a cost-benefit analysis of how much it will cost you to pursue it and what is the return. How much legal expenses are involved, maybe most likely out of pocket in advance that you would have to pay for legal services. This is not your traditional car accident where you're pursuing insurance policies. It's a different type of matter. And also matters between individuals can be quite difficult as well. I don't know if your client's an individual or another company or
another company.
Okay. All right. There may be some type of business insurance policy involved. Probably not for breaches of agreements. I don't see any business liability coverage, any business insurance policy that would cover any type of breaches of agreement. That can be somewhat intentional, so it may not be covered. Liability is usually for negligent actions.
I see.
A lot of considerations. A lot of considerations, but I'm happy to walk you through it. I know there's a lot to consider, but I always like to encourage all my clients, let's just take it one step at a time. The very first next indicated step, and then more will be revealed. Okay, the dominoes will start falling into place, and cases and claims take twists and turns of their own. More will be revealed, and then we'll consider your case, the situation, after each significant event. And each significant event essentially is each correspondence made by your representation to the other party, any filing, any initiation of a complaint. Those are significant events.
Okay.
I do see there's some people watching online. If you have any questions, please feel free to type it in the chat, and I'll try to get to it as soon as possible. Any other questions, ma'am?
No, but I would like to speak to someone about this.
Sure. If you'd like, please, can you message us your email? Do you have my email? Let me put it in the chat.
Okay. Hold on one sec.
All right, I put my email in the chat to everyone.
Okay. You want me to give you my email?
Yes, if you can. If you can, yeah, if you could just message me directly or in the chat, that's fine.
Okay.
We do offer confidential consultations for these type of cases for a deductible fee that would be credited and applied to any future legal services. We just need to take a small fee so we can reserve our time and prioritize our caseload, as we are very busy and I need to set time aside to handle a new matter. I hope you can understand. But I do have your email, and I will send you the information as soon as we log off. If you're happy, if you're happy with the information that you got here, we do really appreciate positive reviews. It's a great way to say thank you. So I also will post information on how to leave a positive review on Google. We do appreciate Google reviews, and I have a business profile and also an individual professional profile. If you have the ability to leave any reviews, I'm happy to be of service and provide any information I can.
Okay, thank you.
So let me just put that in the chat. Oh, hang on. In the wrong. So I'm posting that information in the chat. Let me just take a look online to see if anyone has a question. We are streaming. If anyone has a question, please feel free to type it in the chat. And I will allow one more opportunity to ask any other question before we adjourn. Anything else we can be of service for?
No, not that I can think of.
Okay. Well, I look forward to speaking further with you. I'll send you some information on how we can proceed. And I just would like to say thank you for signing on. We're here every Monday, 9 a.m. Pacific Standard Time. Great way to start the week. Let's take care of our important legal matters in the beginning so that we can cruise through the week, focus on them early on, tap in with us. Every Monday, 9 a.m. Pacific Standard Time. Consider us your source to stay on track for your important legal matters. We're here to help. If I can't help you, I'll do my best to get you to the attorney who can. I have a large network of colleagues that I can make referrals to and associate, and we have local counsel throughout the country. We have local counsel relationships in many jurisdictions.
Okay.
Okay. Well, with that being said, I want to say thank you. Take care, take action, and have a good week.
Do the same.
All right.
Thank you.
Bye-bye.
Bye-bye.